Oh, we are live. Now we may be live speaking to ourselves, by the way. That's very
Right.
possible. I think it is, by the way, which would be
Yeah, I
interesting.
think so too.
Which is interesting. So, JR, how are you this morning?
I'm good. I'm
Good.
good. So Richard has graciously allowed me to make the first comment. And it was something I jokingly
Do you
said
want to
on a
wait and
space.
see if somebody joins before you make the comment?
No, let him watch it. I jokingly said it on a space that the thing I was most excited for today was to learn the correct pronunciation. And it started off good. It was Jarkesy. That's what Chief Justice
Yes.
Roberts said. So
Yeah.
we assumed that was correct. And about 30, 40 minutes into it, we realized that we are not the only ones that don't know how to pronounce this case.
Yes.
The justices struggled with it as well, too. I think we got two other versions of what the case name was throughout the first half of the argument. So it'll
Yes.
be interesting to see where they land at the end of it.
Yeah.
So
And just to kind of like procedurally what we're gonna do. So it took a lot more than the scheduled time for them to conduct the hearing. So we watched the SEC's portion of the hearing, which is basically maybe a 5-minute opening argument, maybe 5 minutes. It was very short.
yeah,
I didn't think it really added anything. And then the justices went back and forth asking questions for about an hour or so. And at that point in time,
it was an hour and 10 minutes exactly.
and at that point in time, the other side was going to start, and we cut it off because we didn't want to leave people hanging. We wanted to at least address it. So whoever's out there watching this, we're going to briefly kind of give you our view of the first half. We're going to go back and some point in time today watch the second half, and we're going to do another live stream after the second half and kind of put it all together. So, of course, before we start, I have to address a couple of things. I accidentally swallowed some Scrabble tiles last night. My next trip to the bathroom could spell disaster. You know, this is interesting, by the way. They all laughed when I said I wanted to be a comedian. They're not laughing now. And last, this morning I was staring at my naked body in the mirror and thought, I'm going to get kicked out of this IKEA store. Anyway, so the first about an hour and 15 minutes was the SEC's presentation. Although there's 3 issues in this case. So if you looked before the case, this is Jarkesy, whatever, and we feel good not being able to pronounce it because nobody can pronounce it. But the 3 issues were, was there a right to a jury trial under the 7th Amendment, the non-delegation doctrine, and the appointments clause? And in the hour and 10 or 15 minutes, the only issue that was addressed was the 7th Amendment right to a jury trial. And the basic question is, if there's an action against you for a fine by the government, do you have a right to a jury trial? And beyond that, the question is whether the government can basically assign the right to adjudicate the wrong either to an administrative agency or a court. Is that okay? And that was a lot of the questioning. And according to the 7th Amendment, there was one particular case that the SEC kept on relying upon, was the Atlas roofing case, which apparently is about 50 years old. And in that case, it basically said that if the government fines you per a governmental statute, that's not subject to the 7th Amendment. So you have no right to a jury trial. So the justices went back and forth kind of exploring that area, and some of it concerned about what would be, in essence, the fairness if the government could elect to decide to deprive you of certain rights. What would the sense be in that if they wanted to, they could provide you a jury trial on some things and on the same claim not. And to make that the distinction, and again, I don't think this is really clear. And while I was watching the hearing, I kind of looked it up. They kind of tried to distinguish between a public right, so that would be anything that was per a federal statute, versus a private right. And so if it involved like a private right or a common law claim, like a simple fraud claim, that you would be entitled to a Seventh Amendment right to a jury trial. But if it wasn't a common law claim, like a straightforward fraud claim, if it was a claim arising out of a new government statute, then you weren't entitled to a Seventh Amendment right to a jury trial. I was kind of trying to figure out from the questioning on the first half how I thought the whole court thought of the issue, and it seemed to me that they were somewhat skeptical of the SEC's, I wouldn't even limit to the SEC, to regulators' ability to make that choice. It seemed to be they had quite a bit of skepticism. Now, we hadn't heard yet from the other side, so they may be equally skeptical of the other side. And sometimes questions are asked because someone wants you to illustrate a point for them. So there may be reasons why questions are asked as independent of they don't believe you. But that was kind of my impression of that. Now I'm going to let JR say what he viewed from the first half.
So, like we talked right before we started, SEC, the acronym SEC wasn't even mentioned until about 50 minutes into the oral argument. And right off the bat, you knew based on the questions, even Justice Thomas was the first one to ask a question, which surprised me. I see the court as viewing this case from a much broader standpoint than the narrow issue that the SEC was trying to make it. And the reason I think that is because of a question I thought Justice Roberts had asked to basically end this individual's oral argument, and it was only about 40 minutes in at that point. He basically said, look, when Atlas Roofing was decided by the court back in 1976, this issue was much smaller. This notion of federal agencies involved in everyday American lives wasn't even that big of a deal. But over the last 50, that's actually 46 years, that's no longer the case. The federal government is in everyone's lives every single day, and it's via these agencies. And I thought that was where the oral argument was going to end, but then it continued on for another 30 minutes, which is surprising. But now looking back on it, it's not surprising because this is the only case that's being argued today. So kind of hearing the arguments, there was a lot of emphasis on, from the justices, the public right versus the private right. There was a tremendous amount of, all the emphasis was on the Seventh Amendment and when these cases become basically jury eligible versus not jury eligible. And so it made me think that, they're viewing this case from a much broader standpoint on American life and are really taking a serious look at this part of the regulatory scheme and whether or not it's time to maybe, curtail some of the government's intervention and basically the government taking away an individual's right to a jury trial. That's how I read the first half of the argument. But to your point, they could be hammering the individual that's arguing Jarkesy's position right now. We don't know it because we obviously didn't expect this to go an hour and 15 minutes.
And that's probably why also when we were talking about Alpine and there have been like 50 friends of the court briefs filed, that's why. Because people, at least lawyers who are litigating at that level, feel there's a reasonable chance that the Alpine matter may end up before the same court, and they're laying the groundwork for those arguments. And and the similarity, I guess, the similarity between the case they're talking about now, Jarkesy, who was, I think, fined. That's the issue. And Alpine, who was fined, is that. There's a fine involved. And if, in fact, since the court to this point in time has solely focused on the Seventh Amendment, solely, so as if to this point in time, and again, it'll change because we have we're taking an intermission, a popcorn break.
Right.
But to this point in time, the way, if you were going to analyze it, and if you were going to think, if the court's going to rule against the SEC, it's going to be on the Seventh Amendment. We're not even going to touch the non-delegation and appointments clause. And that's what they'll say.
Right.
We don't have to reach those issues, so we won't. It would seem odd to me if they're going to rule against the SEC on the non-delegation and appointments clause issues because they haven't addressed it. So I think it's one or the other. Either they're going to find a way to say the Seventh Amendment doesn't apply, or they'll find a way and say the Seventh Amendment applies when you have, and I'm going to extrapolate what the ruling would be. And I don't know what the ruling is going to be. It's more guesswork. But I would say if they find there's a Seventh Amendment violation, they're going to say, so we're not going to get rid of the SEC, of course, but whenever there is a situation where the SEC is seeking a penalty or fine, their choice of pursuing that relief is only in the federal court. And that would be the ruling. There'll be no right for an administrative proceeding. It will be solely in the federal court. You were going to say something. Go for it.
Well, I think they focused on the Seventh Amendment because the Seventh Amendment deals with the individual right to a trial by jury. I didn't ever think that there was a question about the delegation of authority or the appointments clause because, again, that's been the history and tradition and basically the foundation of administrative law. I mean, to argue that Congress didn't have the delegation power or was able to appoint out, this level of authority. I think those were really those are the issues where, you're either going to expand it further or you're going to really narrow it. And if you narrow it too much, now does the federal government have the capability of regulating, again, not just the SEC, but basically all areas of life? One of the things that I thought about was a distinction that I thought they were going to go down this path because they mentioned it, but then they totally did it. And they were talking about this being in everyday life. And the bulk of these kind of issues come up with the Social Security Administration and a denial of benefits. So is it a stretch for the court to say, well, we're going to narrow the issue, and this issue of civil penalties that need to be imposed by an agency, those have to fall under Article 3 courts. But if we're talking about a denial of benefits, those can still be determined by, an administrative agency. But is that now the slippery slope? Well, how do you make the distinction between a civil penalty and a governmental benefit? And as with all case law, the further away from the seminal case you get, the easier it becomes to make those arguments because you kind of have these more periphery issues that crop up. And then all of a sudden you have a totality of things saying one thing or the other. I thought that was an interesting point that they made.
Yeah. And, again, when you hear a hearing, you have no idea what's significant, what's not significant. What thing that struck my attention was basically, I don't remember which justice did it, but he indicated, or he was able to get the SEC to indicate there was only 3 administrative law judges. So how many cases could there be? So how big an issue really is this if you have to go to federal court? That I drew the latter argument. But there's only 3 administrative law judges who are handling SEC matters. They can only
and it used to be 5.
Yeah, it used to be 5. So there's less now. So there's more. So I drew from that. So SEC. So what's the big deal? So you have to take your 3 cases to the federal courts as opposed to doing them in your own. I'm exaggerating 3 cases, but it can't be a boatload of cases. And the justice said that. He intimated it wasn't a boatload of cases. Again, this case is bigger than the SEC because it's going to apply basically, I think that's the issue that the SEC attorney was trying to make. It's going to apply to all regulatory bodies.
Well,
all regulatory bodies that have some kind of adjudicatory system.
But you heard him say it like 2 or 3 different times. Look, if you're talking about doing X, Y, and Z, this is not the case to do it in.
Yes.
And they kept coming back to it. I mean, he basically said that at least 3 times.
Yes.
So
yes.
he even got the sense that the questions were leaning towards, we think this is a real problem. We think it's a real problem because the administrative foundation is totally gone from what it was meant to be, and it's now become way bigger than it ever should have.
Yeah, he said that was interesting because he made a comment. Says the attorney for the SEC. I didn't think, by the way, he was exceptional. I thought he was okay. He didn't knock my socks off. But at one point,
he pissed off a couple of them.
He pissed off Gorsuch at one point in time.
Yeah, he did.
But yeah, and Gorsuch let him know. But what struck me is that he was, I don't remember what he was answering, but at some point in time, he said to the effect, I kind of understand what the court is thinking by their questions. And it wasn't pro him, that statement. No. He was concerned by their interpretation of the 7th Amendment. And that's what he was reflecting back. And he was relying specifically on, and it's a good tactic. There's existing law. He was relying upon that. There were a couple cases so Atlas Roofing was the case he was relying upon. There were a couple cases that apparently came afterwards, and there was a justice at some point in time who said those cases specifically overruled at least portions of Atlas Roofing. And he was asked about that also. So, again, we don't know if this is just banter and they're just illustrating issues and that's their job. That's how they work. Or that it's meaningful. My impression was it wasn't just banter. It was really positioning and meaningful.
Yeah.
But we're going to listen. We're going to listen to the second half. We'll, again, set up a second live stream, and we're going to kind of put it all together. And after seeing the second half and having a chance to kind of ponder it a little bit, we'll come back and give you our view, because we think, because we talked about this, we think that, again, if there's a 7th Amendment right to a jury trial, that's going to impact not just the agencies, but I think it's going to impact all the SROs too. And that one of those SROs will be FINRA.
I think it's going to depend on, the whether it's a narrowly decided in terms of just the SEC or whether it's broadly decided. And based on the questions I was hearing, it looks like there's going to be a broader interpretation of this that are going to impact every agency.
And my distinction about what you just said is I think the narrow decision will be if they exclude ruling on the non-delegation and appointments clause, and they just focus solely on that 7th Amendment issue involving a fine or penalty. That's the box. If the government's going after you for a fine or penalty, you're entitled to a jury trial. That might be the conclusion.
Well, I think for me, what was telling that makes me think they're looking more broadly at it is they didn't even talk about the facts of this case.
No.
There was no discussion on the facts of this case.
No.
And that's what makes me think, look, they're looking at this from a basic constitutional principle. Does the agency have the right to remove that right under the 7th Amendment of a jury trial? And if they do, or if they don't, why not? If they do, what are the instances in which they can?
Yeah, and
clearly the agencies have grown much larger than the intent of this was supposed to be.
Yeah, in essence, same facts, different people. Let's say the SEC was going after JR and I in 2 separate cases. Same facts. They could decide, one, JR, we're going to do an administrative hearing, no right to jury trial. Hoffman, he gets a Article 3 right to a jury trial. Same facts, same claims. What's the logic in that? To me, that sounds, that when you look for why statutes and rulings are overturned, the terminology arbitrary and capricious, it doesn't make a lot of sense. Why you'd be able to choose one or the other without classifying these kind of claims, you have a right. These kind of claims, you don't have a right. But everybody should be treated fairly. What SEC attorneys said, your kind of protection So if the SEC is going against JR and I, and they decided different forums, one in federal court, one in before the SEC, what the SEC attorney said your protection is the due process clause. So that even if they do that stupid trial in front of the SEC, they got to give you a minimum level of due process. And if they don't, that's your protection. Even though you don't have a Seventh Amendment right to a jury trial, you have a right to fair process. So,
well, he didn't really address that question when it was asked. He fell back on kind of, well, that's how the statute was written, but he didn't answer it. And I was surprised that one of the justices didn't say, well, what is the distinction? What is your position? The distinction is.
Yeah,
he didn't have a good answer.
No, he did not. Yeah. Anything else you want to add?
No, I will tell you, I just that, when we were talking about this and going into it, we thought this was really going to be more of a narrowly construed case, limited. And clearly that was not the issue. I think in my opinion, and I could be, totally wrong, but I think this is a bigger case and is going to have more broader implications on society than obviously what we had been talking about up to this point in terms of securities rules and that kind of stuff.
Yeah.
I really think this might be a very important case. I'm going to go as far to say as it might even be a law school case in administrative law.
And we might even be teaching the class. Is that true?
And we could be teaching the class. That's right.
But it also might be the case, because we'll see this too, because we're not going to see a decision, for a few months. But it might be a case where they start whittling situations down, and as opposed to making a dramatic change, they start just removing things piece by piece. So, for example, where they require an Article 3 court if there's a fine and penalty, and that's where they drop it off. They don't touch anything else. They could do that too. So we're not going to know that for months, and we'll see. So anyway, what we're going to do now is we're going to sign off. At some point in time today, within the next few hours, I think both of us, we're going to watch the second half, and I'm going to give at least a couple hours notice of our live stream later today. And when we come back, we'll do the second half. And after seeing the second half, we'll see if our opinions have changed, and we'll see if they focus on different issues. It should be interesting because we kind of went out on the limb based on what we saw this morning. We'll see how serious they were about it this morning, or if that was just kind of like they grilled the SEC and now they're going to grill the other attorney. It'll be very
interesting. If both of them were on the hot seat. Let's say let's say that.
Right. And again, we think that it may be very important to Alpine GTII. That's kind of where it may next go. So anyway, we'll give you plenty of notice to the extent we can, and we'll talk later. And again, thanks for hanging out here, and we'll be back later on today. And if, by the way, if anybody else wants to watch the Supreme Court hearing themselves, it was, just to be honest, it was pretty technical. It wasn't, as JR said, it wasn't really fact specific. So it might be difficult to follow, but it might be interesting to listen to. If you go to the official Supreme Court website homepage, on that page, you will see the ability to watch or to listen to the oral argument. So you may want to listen to it. Up to you. But anyway, see you guys later. Thanks for hanging out.